So good morning, everybody. For those of you that are just joining, and for those that haven't met me before, my name is Kirsty Varley. I'm a partner and a higher courts advocate in the housing litigation team, focusing mainly on antisocial behaviour. And today we're going to look at the issue of mental health in possession claims. And this will allow us to focus on specifically possession cases, as in my experience, and I'm sure it will be yours as well, possession cases are much more likely to go ahead when a defendant has a mental health condition than an injunction, for obvious reasons, especially where capacity is an issue. I'll also share some hints and tips that we've picked up at Forbes to help you to navigate possession claims where mental health is or could be a factor in proceedings. And there will be the opportunity for questions and sharing experiences and best practice. The chat function is open and the Q&A function is as well. So anything that appears in there, I will address at the end once I've been through the slides. So, moving on to the first slide, before we discuss mental health and possession claims, I wanted to really set the scene just by recapping the two main different regimes that registered providers and local authorities operate under. And there are similarities between them. Both have mandatory and discretionary elements to them, and both can offer introductory and/or starter tenancies. But for the purposes of today, given the time constraints that we're operating under, I presume that we're dealing with either secured or assured tenancies. And as I'm sure everybody's aware, local authorities have tenancies under the Housing Act 1985. Registered providers will usually have tenancies under the Housing Act 1988, and the legislation that's used obviously depends on the status of the landlord. Now, it's really important that you plead the correct legislation and grounds and use the correct notices, as they are different. So the Housing Act 1985, this is used by local authority landlords, as I've already alluded to, and I'm going to look at the most commonly used grounds in order to set the scene, although in the spirit of all good disclaimers, there are other grounds available. So the discretionary grounds that are most commonly used are contained within Schedule 2 of that Act. And the ones that, as I say, are most commonly used, ground 1 is where rent lawfully due from the tenant hasn't been paid, or an obligation of the tenancy has been broken or not performed. And this ground encompasses both rent and other breaches of tenancy. Just a point to note, they are separated in the 1988 Act. So that's an example of where your pleading and drafting of the relevant acts needs to be correct. At ground 2, this is where the tenant or a person residing in or a visitor to the property has been guilty of causing nuisance and annoyance to another person in the locality, has been guilty of causing nuisance or annoyance to the landlord, or they've been convicted of using the property for immoral or illegal purposes, or an indictable offence has been committed in the locality of the property. So that is in effect the antisocial behaviour and nuisance to landlord ground. And under the 1985 Act, there's also the mandatory ground for possession. And you've got the 5 conditions. I'm sure everybody's familiar with them, but just as I say, as a quick recap, condition 1 is that the tenant or a person residing in or a visitor to the property has been convicted of a serious offence, and the serious offences are contained within Schedule to the Housing Act. Also, the offence has to be committed within the locality, and there are other caveats. Condition 2 is the breach of injunction, the antisocial behaviour injunction, other than a positive requirement to participate in a particular activity. Condition 3 is that the tenant or a person residing in or a visitor to the property has been convicted of breach of a criminal behaviour order. Condition 4 is the closure order provision, and condition 5 is that the tenant or a person residing in or a visitor to the property has been convicted of a breach of noise abatement notice. So again, just a whistle-stop tour really. Now looking at the Housing Act 1988, this is usually used by housing providers and will be familiar to social landlords. Again, there are mandatory and discretionary grounds available in the Housing Act 1988, and the most commonly used discretionary grounds are ground 10, which is where there's some rent unpaid at the date of the service of the NOSP, and it remains unpaid at the date of the hearing. At ground 11, which is the persistent non-payment of rent ground. So you usually plead those two together, because if the defendant manages to clear the rent arrears under ground 10, ground 11 really looks at the behaviour and the conduct of the way that the rent is paid over the tenancy. So that would still give you a ground even if the arrears have been cleared. Then ground 12, which is an obligation of the tenancy other than payment of rent has been broken or not performed. So again, just to note the difference in drafting with ground 1 in the 1985 Act. So you wouldn't plead ground 12 for a rent case under a tenancy governed by the 1988 Act. And then ground 14, this is the nuisance or annoyance antisocial behaviour ground, that also encompasses the property being used for immoral or illegal purposes or an indictable offence being committed in the locality of the property. And there are also mandatory grounds, ground 7A, again with those 5 conditions that we've looked at, and they're the same here. The serious offence that's within the list: proven breach of injunction, a breach of criminal behaviour order, a closure order being imposed on the property, and a breach of a noise abatement notice. And under the Housing Act 1988, there's also the mandatory ground relating to rent at ground 8, and both at the date of the service of the notice and at the date of the hearing. If rent's payable weekly, there needs to be at least 8 weeks worth of rent unpaid. If it's payable monthly, at least 2 months worth of rent unpaid. And if it's payable quarterly, at least 1 quarter's worth of rent is more than 3 months in arrears. And again, there are other provisions relating to if the rent is payable yearly. We would advise, however, that you really do take care before you plead ground 8. I have actually seen this in cases that have been referred to me. Some tenancy agreements, and it's sometimes contained within stock transfer documents as well, state that landlords won't actually rely on ground 8 for rent. So be very careful and make sure that this isn't something that you've precluded yourselves from doing before you issue proceedings. And some policies also say that as well. So if you're thinking about pleading ground 8, please make sure that you haven't precluded yourself from doing that before you even start proceedings. So making the decision to issue possession proceedings. Well, I've alluded to policies and procedures just a moment ago. Have you followed them? Does your policy advocate an escalatory approach towards issuing possession, and have you followed that? There is statutory guidance from the Home Office for frontline professionals when using antisocial behaviour tools and powers, and this was last updated in June of this year, so some quite recent updates. Make sure you read the guidance and make sure you've considered it as it relates to the case that's in front of you. Presuming that you've done all of this and you've got your relevant grounds for possession, you've got your evidence, your witness statement signed, it really is vital, and I can't stress this enough, that the next step is to interrogate your own systems and records for what you know, or more importantly, what your organisation should know about the defendant. So have they disclosed anything on the tenancy sign-up form? Did they need any help with the process? Do you have any medical letters relating to the defendant's health, or have any adaptations been considered? Is anyone authorised to speak to you on their behalf? Have they ever applied for a move, and have you got any medical evidence supporting this? So as a landlord, if you've been given any of this type of information, then you will be judged to be on notice about this, and you will be expected to factor it into your decisions. And reasons such as different teams use different systems really won't be a defence. So check very carefully, as anything that you do have will come out in disclosure at some point in proceedings, and it could prove to be very costly if it's been missed, misfiled, or forgotten about, particularly if it relates to a protected characteristic, disability, or a mental health condition. And another tip, if you have had other proceedings in relation to the defendant, so for example, if you have gone for the escalatory approach and you've had an injunction against the person in the past, maybe a few years ago, and the ASB has continued and you decided to go for possession, did you have any reports or anything in relation to the person then, because if you have had in the past, again, you're on notice of anything that's within those reports. Do any of the partner agencies who you've got information sharing agreements with know anything, and find out what you can, check what you already have, because it really could save a lot of time, money, and in worst case scenario, reputational damage in the long run. So preparing and serving the notice of seeking possession. While this is technically a step that's taken before your legal proceedings start, it is really a legal step that you're taking, because the correct notice must be served unless you're able to ask the court for and receive permission to dispense with serving a notice. And just a point to note, you can't always do that depending on the grounds that you're being relied on. So some of the mandatory grounds, you can't, the court can't dispense with service of the notice, so you wouldn't be able to do that. And proceedings could potentially fail if your notice is wrong. Also, the defence is likely to argue that receipt of a notice of seeking possession is a step that puts the defendant at a disadvantage. It is the first step in regaining possession of the property. And so on that basis, it really should be subject to the same scrutiny as the decision to issue possession proceedings. And I've listed there some of the defences that we often see to possession claims. I've seen defences that say the decision to serve a notice was discriminatory. Section 149, the public sector equality duty, is often quoted, as is Section 15, which is discrimination on the grounds of disability, and Section 35. That covers discrimination when you're managing premises and seeking eviction against a defendant. And it really makes it much harder to argue, or certainly puts you on the back foot when you're arguing that it wasn't discriminatory and you've considered all of these things if you haven't undertaken an Equality Act review before you've served your notice. So if your Equality Act review is dated after you've served the NOSP, have you really been considering those things, and were they in the forefront of your mind before you served the notice? And just to sort of clarify, it is much more difficult to unpick those areas really that can be attacked by defendants once proceedings are issued. So keep your Equality Act reviews in the forefront of your mind at all times. So issuing the claim and planning the first hearing. So you've got your case prepared, your witness evidence is signed, you've got your NOSP ready, it's been served, or you're thinking about serving it, and the appropriate notice is being given to the defendant depending upon the grounds that are being relied on. Again, you really need to think at this stage about any information you've got about the defendant and the mental health. Do you know, for example, that the defendant may have anxiety about receiving post, for example? Do they have a support worker that attends and helps them on certain days? Could you serve any notices then? Can the defendant read? Are there any learning difficulties to be considered? So all of these things should impact on how the notice is served, and would it be better and more beneficial for the defendant, for example, to arrange an appointment and get them to come into your offices, serve the notice at your offices with a support worker present. And when you're thinking about the first hearing, serving the claim form, is it appropriate to let the court do it? Will it add to any issues that the defendant might have? Again, think about that in the same way as the notice. And if other methods need to be considered, if you mark the papers accordingly, the court won't then serve the papers as they would do ordinarily. They'll return them to you, and then you can serve them. And when you receive the first hearing and it's been listed, again, look at, is it an attended hearing? If it is attended, again, what information have you got about the defendants, and will they be able to attend? So, for example, I once had a defendant who, in and amongst other mental health conditions that she suffered from, she was severely agoraphobic and couldn't leave the house. And so once we were made aware of that, her attendance by telephone was offered. Many courts are offering hybrid hearings now, especially post-pandemic, and so this should be considered. If the defendant has a support worker, it's good practice really to involve them so that they can offer insights, help you engage with the defendant, and help the defendant to engage with the court process overall. Does the defendant have details of defence solicitors? Because if the defendant is vulnerable, then they really should be signposted to solicitors who will be able to help with legal aid, applications, etc. And many courts offer a duty solicitor scheme, and so again, this could assist with accessing advice for the defendant. So issues that are likely to arise. Well, when the defendant goes to see a solicitor or contacts the duty solicitor, if there are any concerns about the mental health, then a psychiatric report is likely to be ordered. And the court can order one of its own volition as well if it becomes concerned about the defendant's mental health. And I know as a claimant, there can sometimes seem to be a reason why proceedings take a long time, adjournments, etc., waiting for appointments with psychiatrists who are in increasingly short supply, waiting for reports, waiting for permission from the defendant for the report to be disclosed, etc. However, I would say in the round, they are positive things. They do allow a real understanding, sometimes for the first time ever, of issues that the defendant faces, and they can give background and context to the way in which the defendant manages the tenancy. It can also allow you as landlords to consider any reasonable adjustments that you might not have been aware of before. If the defendant or their solicitor raises mental health and capacity as an issue in proceedings, then the court will always give permission for that to be explored. If the court refused that, then the refusal could be discriminatory treatment by the court towards the defendant. And so an issue of that importance will always be the subject of the report. And as an aside, not every report does find that there are mental health conditions, and those that do don't always find that it's linked to the grounds relied on for possession. So in summary, perhaps approach each case as though there is or maybe the potential for a psychiatric report. And if you're going to approach cases in that way, what can you do to reduce delays before any further hearings, or in fact before the first hearing? So firstly, find out as much as you can and as much as possible about the defendant's mental health. I appreciate that isn't always easy. There are often issues with information sharing, confidentiality issues, etc. But if you really do everything that you can to find out what you can about the defendant's mental health, that puts you in a good position. As I've already alluded to, consult your own files. There may be just little nuggets of information hidden away somewhere, as I say, on the tenancy sign-up form, etc. There could just be something that could alert you to potential issues. Does the defendant have anyone assisting him with the tenancy? And you could be thinking further down the line, if capacity becomes an issue, is this person who is assisting the defendant with the tenancy a potential litigation friend, for example, in the future, if needed? I would always advise you to contact any professionals that are involved with the defendant, excuse me, and find out how they assist the defendant. And also, does the defendant have a Care Act assessment? If they have one already, housing should be covered, or is another one needed if it isn't? Addressing all of these things early could save lots of time, because I guarantee they are things that will be raised by the defendant's solicitors. And if you're thinking about them at the start of the case, you're reducing any potential delays further on down the line. So, dealing with psychiatric reports. Well, when the report identifies a mental health condition that hasn't previously been identified, you should always undertake a fresh Equality Act review as soon as you receive the report, and consider all steps that have been taken, including whether the proceedings should actually continue or not. And you need to do that on the basis of the information that you've got in front of you. You need to consider whether any treatment that's been identified is being taken up by the defendant. So is the defendant engaging with the court process, with their solicitors, with you as landlords, and with any medical professionals? Is the mental health condition that's been identified linked to the behaviour that's being complained of? So if it is, for example, something like schizophrenia, which can be treated quite well with drugs, will treatment abate the behaviour, and is that something that needs to be factored into decisions? So justifying decisions and offering support. Once you've received a report, it might be that negotiations between parties start. If offers are made and rejected, and counter offers are made by landlords, then you really should be undertaking, or at least revisiting, any existing Equality Act reviews on each occasion to justify your approach and withstand any scrutiny from the court at a later date. Can you as a landlord offer anything from within your own organisation by way of tenancy support? And I appreciate that will vary considerably depending upon the size of your organisation, the resources that you've got available. And also consider, is this something that would have been available to the defendant if their condition had been known earlier? If it is, then that is certainly something that should be considered. So it's really important to keep your Equality Act reviews at the forefront of everything. Each new piece of information should be considered. And if you don't think a new Equality Act review is needed, make a file note just to say that you've considered whether you needed to do a new review or not. Because remember, each decision that you take in proceedings could be the subject of cross-examination when you get to a trial. So if we get a report back and the defendant lacks capacity to litigate, well, the rules around that are contained within CPR 21. We actually did a session on this recently, just on this particular topic. A defendant who lacks capacity to litigate, well, this doesn't mean that proceedings have to be halted, but it does mean that there are some procedural safeguards that need to be put in place. A person who lacks capacity will be known as a protected party, and that will appear on all of your court orders once that's been established. And a protected party has to have somebody called a litigation friend to conduct proceedings on their behalf. And the only requirements to being a litigation friend are that the person can fairly and competently conduct proceedings on behalf of the protected party and has no adverse interests to the protected party. So a family member or a friend, or for example, the person who may be assisting the tenant with the conduct and management of their tenancy could, in theory, be a litigation friend. And they can become a litigation friend without a court order. They just file a certificate of suitability saying that they can fulfil the requirements we've just gone through and then serve it on everybody who's a party. If that isn't done, the court can appoint a litigation friend by way of court order. Again, they need to be satisfied that that person fulfills those requirements. And if a litigation friend can't be found, then an application is usually made to the official solicitor. That can take some time, and unfortunately that is out of your hands as a landlord, as a claimant, out of the defendant's hands, defendant solicitor's hands. It's just a waiting game, unfortunately. The official solicitor's criteria are that there's evidence that the defendant lacks capacity to conduct the legal proceedings on their own, that they've got liquid funds, so really that they can meet the official solicitor's costs, and if the defendant has a benefit of legal aid, that will cover that, and that this is the last resort for the defendant. And when they're on board, they can then make decisions that are relevant to the litigation that a litigation friend would make otherwise. So negotiating when a defendant lacks capacity, and really we're looking here at when you're in possession proceedings, and it may be the view of all parties, including the defendant solicitors, that ending a tenancy would be in the defendant's best interests. Now, if the defendant lacks capacity to do this, then the decision has to be made by another party, and it couldn't be made by the official solicitor. So you'd then look at whether there's somebody with an enduring or lasting power of attorney who could make decisions on the behalf. They could potentially terminate the tenancy. Is there a property or an affairs deputy that's been appointed by the Court of Protection? If so, then they could end the tenancy. And if there's nobody with the authority to do this, then an application would need to be made to the Court of Protection. Again, we did do a session on this a little while ago. Ideally, you want the local authority to make that application for the order, giving them the authority then to end the tenancy. You'd have to involve the local authority in social services. They'd need to be involved anyway. It'd be in their interest to do so and to come on board at an early stage as possible, because if a tenancy is ended and the person has serious mental health conditions, then there will be duties owed by the local authority and social services in any event. So, concluding proceedings, if the defendant lacks capacity, there is every chance that they might not be in appropriate accommodation and so can't sustain a tenancy. If that's the case, and I have known this happen, events may overtake proceedings and the defendant could be rehoused by social services and or a specialist provider. That is quite rare, although, as I say, I have known it happen purely from a resources and stock point of view. If the way that your proceedings are concluded is that they are adjourned generally or stayed, or a possession order suspended, if it transpires that the defendant's mental health condition can be treated and there can be conditions put in place to help sustain the tenancy. You then obviously need to monitor the behaviour, make any necessary referrals if there's any perceived deterioration in the defendant's condition. So you'd be looking at referrals to social services, local mental health teams, etc. And if your proceedings have continued, you've obtained possession, then as I've already alluded to, it might well be the case that there are duties owed to that person, homeless duties and the like, and others under National Assistance Act by the local authority. So that is a bit of a whistle-stop tour around mental health and possession proceedings. I can see there are 12 messages in the chat, so I'm going to look at these, and then if anybody would like to ask any questions, I am happy to do so. I can see we've been asked about a copy of the slides. Yes, you will get copies of the slides, and this has been recorded. A link to the guidance. Yes, I will ask Catherine to include a link to the statutory guidance. I presume that was from June 2022, so this year. Everything that I've said, I would say is relevant in Wales as well. This is why I've done broadly, other than the grounds for possession, a very broad overview in terms of how you approach possession claims and mental health generally. It's always good practice to look at your records as an organisation. What do you know about this defendant? Not just what you think you know, what do you actually know? Or more importantly, take a step back. What will the court think that you should have known? And I think if you approach cases in that way, you won't go far wrong. I'm not sure if anybody has any questions. I'm more than happy. Or would anybody like to share any best practice? Does anyone have any recent or ongoing cases that they would like to tell us about? I alluded to one when I did my session that just focused on the Court of Protection, where the landlord suspected that the defendant had some mental health issues. We didn't know for sure. There was nothing sort of written down. That was just what had been gleaned from their interactions with her. And when we ended up in possession proceedings, tried an injunction, that didn't work, ended up in possession proceedings, transpired that she didn't have capacity. All parties, again, as I referred to on one of the slides, decided because of the nature of the antisocial behaviour that was being perpetrated by the defendant that it was better for her to have a clean break, end the tenancy. A new tenancy was found for her elsewhere, and she just refused to terminate the tenancy. And as a result of that, an application to the Court of Protection was being made by the local authority, and the possession proceedings have been stayed. We are awaiting an outcome from the Court of Protection application as yet. And as I say, our proceedings are stayed. So that is certainly my experience of mental health. I've got a question from Andrew Jones. Hello, Andrew. If there are concerns to the mental health of the defendant, but the defendant doesn't engage or visit a GP for the mental health referral, is it still wrong to proceed? That will very much, Andrew, be a question for you as an organisation. So first of all, you have to remember under the Mental Capacity Act 2005, capacity is presumed until there's evidence to the contrary. So you may well suspect that there are some issues, you may well be right, but legally, until you've got any evidence to the contrary, you are entitled to assume that that person has the relevant capacity. I would also balance that with any duties that you've got to your other tenants and residents. So they need to be protected from antisocial behaviour. If it's low level and you think it's something that you can deal with by way of mediation, that's fine. If it's something that's more serious, then you need to think about your duties to protect other residents as well. I hope that is helpful. I've got some other things in the chat. Do we have an example of what an equality assessment looks like and how you fill it in? We do have templates, so if you'd like to drop me an email, my contact details are on the slide at the end, which I will put up. I'm more than happy to share a blank Equality Act assessment, that's fine. Okay, next question. We have a tenant that's got 2 dogs in a scheme that doesn't allow dogs. He states it's helping with his mental health. He's produced a letter from the GP which states that he needs the dogs for his mental health, but he doesn't give any diagnosis. There are other tenancy breaches also. Please advise. Well, that would depend on what the other tenancy breaches are as well. I mean, in relation to the scheme, I think we're looking at reasonable adjustments, aren't we, for this particular person? So is it just a blanket policy that you don't want dogs on the scheme, or is there a good reason why dogs aren't on the scheme? If it's just a blanket policy, then there's the potential for indirect discrimination. Was the tenant aware of this when he or she moved in? And have they got the dogs afterwards? I think given the fact that there's some medical support for it, you really need to be thinking about why this policy is in place, and if there are good reasons for the policy being in place, whether this person should be offered a tenancy elsewhere. I'll just move up a little bit because I can see that there are more questions. We've got a tenant in hospital under a section. Can you proceed with service of the notice during this period? Well, thinking about the Equality Act review that I talked about and the steps, a NOS, service of a NOS being a step that really needs to be considered, and the subject of thinking about your public sector equality duty and things like that. Would it be detrimental to the defendant? Probably. Does the notice need to be served while they're under a section, or could it wait? And what is the mental health condition that the defendant is suffering from? So, for example, if somebody is severely depressed, potentially suicidal, if you then serve a notice on that person while they're sectioned, what impact is that going to have? So that will be a question for you to really look at taking into account everything that I've said. What about seeking possession in a low to medium supported housing service for people with mental health issues? Some with multiple and complex needs. Most of meds, I think that says, and do have capacity. Well, if the people have got capacity, they're causing antisocial behaviour, you've completed your Equality Act review, and you've decided on balance when you factored in all the things that we've talked about, that seeking possession is appropriate, then by all means you can go ahead with it. I've got a question. Is the best practice when dealing with a tenant with a very recent diagnosis of dementia? We did actually do a session, David, on dementia. I'm sure Catherine will be able to send you a link. It wasn't a session that I did. It was a session that my colleague, I think Rebecca, did, along with Manchester United. So there were some really useful hints and tips as regards that. What I would say is dementia is usually a condition that deteriorates. It doesn't get better with time, it usually gets worse. And so depending on what your issues are, it may be that you want to speak to social services. Is the person going in a care home, for example? And again, think through whether they've got any lasting power of attorney, enduring power of attorney, and is there somebody else that can make decisions on this person's behalf? I've got another question from Kaylee Hartland. If somebody's been deemed to have capacity by way of a report, but the solicitors are struggling to get instructions, what's likely to happen? How long will it go on for? We've issued possession proceedings, and we've had an injunction to exclude since April 2022. There could be any number of reasons, Kaylee, why defence solicitors are struggling to get instructions. They may have just stopped engaging. They may have decided they don't want to defend the proceedings, or they don't care, as odd as that may sound to us, but that is the attitude of some people. I'm presuming that if you've issued possession proceedings, I'm not sure whether you've got a court hearing, that the court won't allow that to go on forever, that I can say. In some of the overriding objectives of the court, cases have to be dealt with justly, fairly, and as quickly as possible when taking into account all of those things. So continual adjournments, court time being wasted, etc., isn't something that judges will allow to go on forever. So without knowing the specifics about that, it's a bit more difficult to say, but I would certainly be raising that with the court if you're having more than sort of one or two adjournments, really, and that is the excuse that's given. I had a case yesterday. It was adjourned with directions around capacity. The judge wanted to direct that the landlord was responsible for completing the capacity assessment and not the defendant. Have you had this in the past? I've certainly seen that in cases. I mean, if you're going to fill in a capacity assessment, you're doing it on the basis that you are a landlord and not a mental health professional. And that will, as I say, that will be the basis on which you do it. So I would, if you can, try and get somebody from social services to assist. You might not be able to do so, but at least if you make the referral and you complete the capacity assessment, then you've done all that you can. I've got another question. I've got a resident who's been causing ASB through intermittent noise nuisance and intimidating behaviour, but the evidence is weak. The impact this is having on his neighbours' mental health is significant. We're in the process of serving an NSP, but after what you've said, I'd like some advice on whether it's appropriate, as we suspect the defendant's got mental health, but it hasn't been confirmed. We do know that he suffers from epilepsy, often affected by stress. Any advice would be greatly appreciated. Well, epilepsy may well be, depending on the severity of it, a disability. So that is a protected characteristic under the Equality Act. So that's something, again, that you've got to factor into your decision making. I'm interested when you say that the evidence is weak. Is that, do you mean, is it anonymous? Is it hearsay? The impact on the neighbour's mental health is significant. So the neighbour has mental health and the defendant has mental health. So I'd be doing equality at risk assessments actually for both of those people. And is it something that is a NOSP the right way to go? Would warning letters be more appropriate? For example, could you look at mediation? Is it something that the noise nuisance perhaps could be dealt with by way of mediation and lifestyle? The intimidating behaviour, again, that would depend on how severe that was. If you want to drop me a line, Kelly, I'm more than happy to give some more detailed information. I've got a question from Leigh. Good morning, Leigh. Is the expectation that the landlord pays for the psychiatric report? Not always, that depends. So if you want a say in, if you want a joint instruction and you want to say on who the psychiatrist is, then you will usually be asked by the defence to pay half. And then we get to ask questions and the defence get to ask questions, and that can, it can be advantageous because it can really help to steer the direction of the report. And when I say that, particularly if you're looking at injunctions, there are certain questions that defence solicitors don't ask that I would always ask, that help in terms of whether an injunction should stay in place and whether a defendant can really comply with it, or they just suspect he might not be able to. If, for example, you've got an arrest, so alleged breach of injunction with a power of arrest and there's an arrest, the defendant solicitors usually go and get their own psychiatric report in that instance, and that will depend on whether they want some control over whether it's going to be disclosed or not. So if you pay for half of the report as a landlord, you will receive the report at the same time as the defendant solicitors. If the defendant solicitors don't want you to see the report, then they will go off and get it themselves. We will then have to wait until the defendant gives permission for that report to be disclosed, and at that point you can then ask questions of the psychiatrist afterwards. Now, it's an important note here, because that does sound a little bit unfair. If the report is never disclosed to the landlord and the court, it can't be relied on either. So it's not as though they can just go off and get a site report and not tell anybody and benefit from it. If they want to rely on it, they have to tell you, and you can ask questions at that point. I think there's some other. Okay, Michelle Kent has asked for the link around the session on capacity. You've already answered that, Catherine. I can see further on down. Sorry, you're going a lot quicker than I am. I'm trying to answer and read and talk at the same time. I've then got a question. I've got a case where a tenant's not allowing access to the property. We've got serious concerns in relation to her mental health and social care. I've been trying to get her GP, social services and mental health to engage, but she's not engaging with them and they're not following it up. They won't provide emails or confirmation as they've got no concerns. We haven't been able to get into her property and she hasn't been seen outside of it. Can we proceed? Excuse me, sorry. Well, I would say if your concerns may well be well-founded, but if you haven't got anything on your systems and on your files to suggest that she doesn't have capacity, then, as we've already alluded to, under the Mental Capacity Act, capacity is presumed, so you can take legal action. Now, whether that is by way of an access injunction or you serve a NOSP, that will be for you to decide depending on the information that you've got. But if you haven't got information that the defendant doesn't have capacity, then it's presumed and you can take action. And if it comes to light that they didn't have capacity all along, if you followed the steps that we've outlined in this session and some of the other sessions, it's quite difficult really for the court to level any criticism at a landlord. You can't be expected to act on something that you didn't know about. And I've certainly made those submissions and they've been successful in court. I've got a hoarder refusing help, being obstructive, refusing to leave the property in her 80s. Capacity is there, but she's refusing offers of community care. Fire risks, outstanding repairs. Oh dear, this sounds quite sad reading through this. Injunction was turned down. The GP won't support the tenant or attend safeguard meeting. They feel we've got no option but to go for a NOS. Well, all of those things that you've said, Felicity, would go in your Equality Act review. And actually, that leads me very nicely to plug the next session that we're doing, which my colleague Shirley Farragher is doing. I think it's on the 14th of December. Catherine will correct me if I'm wrong. That is just on hoarding. So we have picked out throughout the year certain mental health conditions that we see in cases. This was more of an overview generally, this session. We just thought it would be helpful to pull things together. But as I say, we've done some on dementia. There was one on autism earlier on in the year, and Shirley's next one is on hoarding. So that would be, I think, very useful for you. It's only in a couple of weeks' time. Again, do your Equality Act review, and if the decision is you need to go for possession, then you need to do that. Especially if you tried an injunction and that wasn't granted, you literally have tried every other tool in your armoury then, haven't you? And I think, so I've got 3 questions in the Q&A. I've answered Andrew. So Catherine, where a person can't sustain a tenancy due to lacking capacity, how do we progress social services supporting them into appropriate accommodation? We find that usually push back on us as a landlord. That will be a familiar story to everybody, I'm sure. The COP takes forever to progress. I agree with that as well. Meanwhile, the situation deteriorates for all. Is there a quick way to progress? That's a difficult question, really. And I think because of the resources issues that local authorities up and down the country are facing, whether you choose to escalate that with senior management at the local authority, and or look at your partnership working, whether somebody senior in your organisation can have a chat with somebody at the council, even at chief exec level, whether that would be the way to go. It perhaps isn't a good idea to get involved in legal proceedings with local authorities. You're going to need one another at some point anyway. I have known that in the past, and it never ends particularly well. So see what you can do in terms of your partnership working, and escalate it is perhaps the best advice I can give you. And also continue to make referrals and try and speak to the person's GP and any other family members, etc. There are no easy answers with cases like that, unfortunately. I'm just checking that there's nothing else in the web chat. Oh, I was right. Thank you, Catherine. So the hoarding session, just for those of you who are asking about hoarding, is on the 14th of December. So Shirley will be able to address any issues there in a lot more detail than I have done today. Okay, I think that is everything, unless anybody else has any other questions or anything else they'd like to raise and or share. I think that is everything. I'm just going to, just before we end the session, so those are my contact details. I did mention them. So when I was answering questions, if I've said, if you'd like to email me and or give me a call, we can discuss some of the more general points further and or in more detail. My contact details are there. Some very nice comments coming in the web chat, so thank you very much. I'm pleased that it's been helpful. As I say, really important to drill down on some of the some of the mental health conditions that we're seeing, but also we thought it was useful to just pull everything together and just remind landlords, really. We know that you're in a difficult position. We see it all the time, whether you're a registered provider or a local authority. And you can feel sometimes as though you can't get the information that you need, and then you go to court and then everybody expects you to be up to date with everything. And we understand it's very difficult. So really, this is just about trying to damage limitation before the damage has even happened, if I can put it like that. And I'm pleased that's a nice comment. It's not as daunting as it seems if you followed everything. I think that is right. Just do your Equality Act review. Make sure that you've considered all the information that you've got, and then, as I say, capacity is presumed, so you are allowed to proceed on that basis. So I think, unless there is anything else, I will end the session there. I'll leave my details up for the time being. Thank you very much for joining us today. I will certainly be listening to the hoarding session in a couple of weeks, given the number of queries that we've had. So I'd encourage everybody to register and join that. I'm sure it will be really useful. This is the last session that I'm doing before Christmas. So have a very Merry Christmas and a Happy New Year to everybody. And we will hopefully see you soon.